Hello class, and welcome to the week 5 lecture for Introduction to Law. This week we will be discussing chapter 10 in your text, which covers family law. This material will start with prenuptial agreements, then we will discuss marriage, and we will end with a discussion of what happens with a marriage ending, specifically child custody and division of property. So to begin, we will start with a discussion of prenup agreements or antenuptial agreements. These are contracts entered into by parties who are going to be married. They provide for the division of property rights at the time the marital relationship between the parties ends. Originally, these agreements dealt only with property division on the death of the spouse. Ordinarily, one spouse cannot entirely disinherit the other. If no provisions are made by will, then the surviving spouse can elect under a special statute, and this statute does exist in each state, to receive a percentage of the estate. In a traditional antenuptial agreement, each spouse may agree by contract not to challenge the provisions of the other spouse's will. This is often done when one spouse possesses a great deal more wealth, or when one of the spouses has children from a previous marriage and seeks to protect the child's inheritance. And some parties attempt to arrange in advance for the orderly distribution of debts and assets should the marriage be dissolved. This can be a reasonable alternative for spouses who each have a career and the ability to contribute financially to the relationship, as well for those who need to protect the interests of the children from a previous relation. And as stated earlier, this agreement is essentially a contract, and it must contain the necessary elements of any contract. Most states require the agreement to be in writing, and there can be an exception of this writing requirement when one party can demonstrate that he or she has significantly altered his or her position in a detrimental manner as a direct result of reliance on the other party's promises in an oral antenuptial agreement. In addition to the writing requirement, consideration, which is a voluntary element of value that we will discuss in further detail in our contracts lecture, must be given for the promises of each party in the antenuptial agreement. Traditionally, the promise of marriage by each party has served as consideration for the other party's agreement to the terms of the antenuptial contract. A valid antenuptial agreement must be made with the free will of both parties without duress, coercion, conditional on divorce, and it must not be unconscionable either when made or implemented. With regard to assent, the courts examine whether an unscrupulous person took advantage of the position of another and persuaded the other person to enter an agreement that, in the event of divorce, was inherently unfair. This is known as overreaching. In addition, the agreement should contain provisions for some fair and reasonable economic settlement. The parties do not usually anticipate divorce and cannot anticipate what their accumulation of wealth will be at the time of divorce. However, they can anticipate that each will contribute to the marriage, and assets should be divided in a manner fair to each based on that contribution. And courts will often not recognize an agreement that provides for a specific financial award, such it is seen as encouraging dissolution of the marriage in an attempt to obtain a monetary settlement. As you can see, there are very many preconditions that must be satisfied in order for a court to give effect to these agreements. So, as always, an attorney is necessary when drafting one that can hope to withstand the scrutiny of a judge. All right, and moving on past antenuptial agreements, we will next discuss the requirements that must be met in order for parties to get married. Every state has enacted laws that set forth certain requirements that must be met before a recognized marriage will exist. For a marriage to be valid, there must be capacity and voluntary consent. Capacity requires legal age and legal competence to enter into a binding relationship. Many states also have provisions for parental or court consent in the event a party to the marriage is not of legal age or has been legally determined to be incapable of appreciating the consequences and responsibilities of marriage. Each state also has a licensure provision for marriage. The license is generally granted unless some factor exists that would prevent the marriage from being legal under state law. Examples of such factors include where the parties are family members who have a close blood relationship. On this point, it should be noted that states have different laws regarding which degree of affinity will invalidate a marriage. 2, the parties are persons of the same sex. This is a highly volatile subject, and in some states, same-sex marriages are given full legal recognition. 3, one or both of the parties lack legal capacity. And 4, one of the parties is already in an existing marriage. Blood tests and a waiting period are also often required to obtain a marriage license. The purpose behind blood tests is twofold. In some states, there is a legal presumption that each party has a right to know whether the other carries any sexually transmitted disease that could place the party at risk. The second reason for blood tests is to discover whether there is a conflict between their particular blood types that may make it difficult for them to have healthy children. Although medicine has advanced to the point that most problems can be treated effectively, the parties are still presumed to be entitled to this information. And the statutes that require a waiting period, which is usually only a matter of a couple days, are intended to discourage marriages that are entered into without sufficient thought to the consequences. Additionally, parties are ordinarily required to solemnize the marriage. This involves the exchange of vows, an agreement to marry, in the presence of one who is permitted to legally acknowledge the marriage, an officiant. In some states, additional witnesses are required, and in fact, the traditional roles of maid of honor and best man were witnesses to a marriage. And if citizens of one state wish to marry but would not be permitted to do so in their own state, they may not simply go to another state for the purpose of marrying. Many states have laws that invalidate the marriage if it was entered into another jurisdiction for the purpose of avoiding the first state's laws. And with that discussion of the requirements of marriage, we will now continue to the first way that a marriage may be dissolved, an annulment. A legal annulment is a judicial declaration that a marriage never actually existed because one or more of the legal requirements for a valid marriage were not met. And this needs to be distinguished from a religious annulment, which is granted by a church authority for reasons of and in accordance with religious procedures. A religious annulment has no legal meaning or effect, and a legal annulment has no religious significance. Legal annulments can be obtained for a variety of reasons. It is only required that the recognized reason that the marriage should be declared invalid must have existed at the time the parties entered into a marriage. The general rule is that an annulment may be granted if the reason for the annulment, had it been previously disclosed, would have legally prevented the parties from marriage. At this point, it is important to distinguish two types of annulments. There are some reasons for annulment which will always be granted no matter the future conduct of the parties. This is because these marriages simply have no force and immediately void a marriage if it is made and this condition exists. The two big ones under this would be bigamy and incest. However, there is another group of reasons that may give rise to an annulment, which, if after the party discovers this condition, they opt to continue with the marriage, that the reason for the annulment will fade and the marriage can be allowed to continue. Examples of this include fraud or duress. For example, it is a basis for an annulment if one party to a marriage conceals the fact that they never want children from the other party who does want children. If later the party who does want children finds out about the other party never wanting children, they may request an annulment. However, if they learn about this and they accept it, then that basis for annulment will fade. And at this point, we should discuss these bases for annulment in further detail. If the party seeking an annulment has taken any steps towards accepting or acknowledging the marriage relationship, then the request may be denied on the basis that one who attempts to solemnize a marriage cannot then take the position that the marriage never existed. And as stated earlier, there are some reasons that will nevertheless allow a marriage to be declared invalidated even if the parties have solemnized it, and this includes bigamy and incest. There are less frequently encountered for annulment that include actions based on frolic, duress, or fraud. As with most contractual agreements, intent is required for a valid marriage to exist. The party believes that he or she has no choice but to marry, or alternatively suffer serious physical, financial, or other harm that a marriage of duress has taken place. An annulment on the basis of fraud is one of the most difficult to establish. The party who seeks the annulment must prove all of the necessary elements of fraud. In the case of marriage, the elements are that a misrepresentation misrepresentation of fact essential to the marriage relationship must have been made, and the party claiming fraud must have reasonably relied on the misrepresentation as truth when making the decision to marry. Although an annulment as a declaration that the marriage relationship never existed in the eyes of the law, the court may apportion rights and duties regarding property, assets, debts, and even children as if the annulment were an action for dissolution of marriage, otherwise known as a divorce. The purpose of an annulment is to return the parties to their original position before the marriage. If the parties have contributed anything to the relationship, or if there are children, then the court will consider the rights under the same equitable grounds used in dissolving a marital relationship. And with that discussion, we have concluded our analysis of annulments. We will now move forward towards common law marriages and duties under a marriage. Some states allow marriages created by common law. Such marital relationships are created by agreement and a demonstration of intent by the parties. The courts usually examine the following elements in determining whether a common law marriage exists. Did the parties hold themselves out as to the public as married? Did the parties cohabitate? Did the parties file joint tax returns? And does the conduct of the parties indicate an intent to be married? If the parties do not receive common law status, then they may have legal rights under principles that deal with cohabitation. Continuing on, it is time to discuss the duties that spouses owe to each other once there is a valid marriage. Today, most states have statutes that impose an equal duty on each spouse to aid and financially support the other spouse during marriage. The practical result is that either spouse may be entitled to financial support in the event of dissolution. In most cases, maintenance, or alimony, is no longer awarded for life unless special circumstances exist. Spouses have an ongoing duty to provide support of at least that which is necessary to meet the joint needs of the parties. These include food, shelter, and clothing. If one party has agreed to work outside the home while the other remains at home, then that party also has a duty to provide items necessary to the couple's existence. Often what is considered necessary is largely influenced by the income of the spouses and what income enables the parties to provide. Most states also recognize the theory of marital debt. If one spouse incurs debt, then the other spouse is equally bound. In the event the marriage ends, debts must be apportioned fairly while taking into account the ability of each party to satisfy the claims of outside creditors. And the primary rule regarding existing marriages is the policy of non-intervention. Courts generally refuse to become involved in settling marital disputes regarding the duties of the parties. However, if the parties cease living together and abandon the marital relationship, then the courts may become involved in dictating the legal rights of each party before and after a formal dissolution of the marriage. This includes legal separations and pending dissolutions of marriage. With regard to other areas of law, historically, one spouse was not permitted to bring a legal action against the other spouse for injuries inflicted during the marriage. The reasoning was that marital harmony would be disturbed if courts entertained lawsuits by spouses against one another. Most states have now abolished the doctrine of interspousal tort immunity, however. No longer are parties who cause injury to their spouses immune from legal action. Other torts that affect the marital relationship include the actions of third parties against the marriage. Two such torts, criminal conversation, which is an action by one spouse against a third party for adulterous conduct with the other spouse, and alienation of affection, which is an action by a spouse against a third party who has induced the other spouse to transfer his or her affections to that party. Because these actions have been used as a means to threaten and as virtual extortion or blackmail, some states have abolished the statutes that prevent them. In fact, most states have now abolished these acts. In 1998, the U.S. Department of Justice conducted a study and concluded that between partners alone, not including children and other family members, there were between 1 million and 4 million estimated annual incidents of domestic violence in the United States. Obviously, this is a serious problem confronting marriages, and this is one major reason that interspousal immunity was done away with. there are other privileges that exist in a marriage. For example, in criminal law, certain principles affect the marriage relationship, such as the testimonial privilege. Traditionally, a spouse could not testify against the other spouse during a criminal prosecution. Over time, the law has been modified, and most states now permit, but cannot compel, a spouse to testify against his or her partner, because the spouse has the right to protect the confidentiality of the marriage relationship. Testimony cannot be forced or ordered. And with that discussion of some of the rights, privileges, and immunities that exist through the marital relationship, we will now discuss what happens when the marriage relationship ends through a judicial decree of dissolution, otherwise known as divorce. When one or both of the parties to a marital relationship decide to end the marriage, a judicial declaration must be made before the marriage and its associated rights and duties will be terminated. The declaration must come from the court that has jurisdiction over the parties to the suit, and procedural rules in each state specify when the courts will accept jurisdiction over a marital dissolution action. However, many of these requirements are similar. Perhaps the most common is a requirement of domicile or residency for a specific period of time. Parties may also obtain jurisdiction in the court if the marriage was formalized there, or if the grounds for divorce occurred while the parties maintain their residence in the state, regardless of whether the time requirement has been met. And when a party obtains a decree, but the court does not have jurisdiction to decide matters involving the settlement of the marital estate, for example, in cases where the assets are located in another jurisdiction, then the court may be registered with the court that has jurisdiction over both parties and their properties. That court may then proceed to determine the rights and obligations of each party. Initially, the court that has jurisdiction to determine the rights, duties, and division of assets of the marital estate also has authority to make findings regarding custody, visitation, and support of minor children. However, later adjustments to these findings, commonly termed modifications, may raise serious issues as to which court has authority. These issues have largely been resolved through uniform statutes. One such uniform statute, the Uniform Reciprocal Enforcement of Support Act, or the URESA, and most states adhere to this act, which states quite specifically which courts have jurisdiction over matters concerning children of divorced parties. Although the requirements of jurisdiction vary, the acceptable grounds for divorce set forth by state statute are typically quite similar. And though a slight variations may exist, the basic premise for a dissolution of marriage remains the same. More or less, there must be sufficient evidence of some type that will establish the marital bond is irreparably broken. Traditionally, one of these factors, or one like this, had to be shown in order to end a marriage. However, the modern trend is to create no-fault divorces. The traditional grounds for dissolution of marriage include habitual drunkenness or drug abuse, adultery, physical cruelty, mental cruelty, abandonment, and insanity. These are fault grounds for divorce. However, these days, the concept of no-fault divorce has a grounds of irreconcilable differences, and this has become the basis of choice for divorce. Although the requirements of proof of the broken marriage differ from state to state, the premise remains the same. And it is unnecessary to claim that one party unilaterally caused the break in the marital bond. To prevent parties, however, from entering into a no-fault divorce when conciliation could still be achieved, many states impose requirements of proof that the marital bond is irreparably broken. And during the period between separation and dissolution, the parties remain legally obligated to each other as well as for support of the children. Some parties enter into separation agreements to address such issues as custody, visitation, and support of minor children, possession of the marital residence, responsibility for payments due on marital debts, and maintenance or alimony when appropriate. When parties cannot come to an agreement, state statutes give a court authority to make temporary provisions during the period after the commencement of a divorce but before the final decree is issued. In addition to issuing temporary orders, courts are often requested to issue temporary restraining orders and preliminary injunctions, which are granted in circumstances where the court is convinced that one spouse will injure the party or harm, destroy, or dispose of marital property. And if the threat of harm is immediate, then the spouse in danger of injury or harm or property can appear in court ex parte. An ex parte proceeding is conducted without giving the other party to the action opportunity to be present and voice his or her position. The Because these orders are based only on one person's version of the story, the court will usually issue them in compelling circumstances, and they are only effective for a short period of time. And with that discussion of temporary orders, it is time to discuss the division of custody and assets in further detail. Custody over a minor child describes the care, control, and education of a minor child. It is effective as long as the child is a minor or is still in high school. When the child reaches the age of majority under statute in the state where the child resides, custody ends and the child is considered to be an adult. Residence is determined by the child's permanent dwelling, not by where the child attends school or where the other parent whom the child may visit lives. Generally, the state of residence for custodial parent is the state of residence for the child. Custody may not end at the age of majority for a child with mental disabilities. In cases where the child is unable to accept responsibility for his or her actions, the parent may be appointed a permanent guardian. And in the event of the death of the custodial parent, the presumption is custody will be transferred to the other parent, and the exception to this is if the surviving parent is not able to provide an acceptable environment for the child. Under the tender years doctrine, which was followed for many years, the mother was presumed to be the best alternative for custody of young children of tender years. This is children who have not reached their teens. And the only way the father could overcome this presumption and have a chance for custody was to prove that the mother was unfit, or at least far less able than the father to care for the children. And many courts have struck down the tender years doctrine in face of a case-by-case evaluation of who will serve the best interests and needs of the child. And contrary to popular belief, custody determinations, it is not necessary to prove that the other party is unfit as a parent. Although the evidence may establish this in some cases, it is not the standard by most courts. Rather, the courts will look at what will be in the best interest of the child. The environment that is most compatible with the child's needs is one that is in the child's best interest. This best interest is the overriding concern of the courts when determining custody and indeed anything involving children. And the factors the courts consider in making this determination may include, but are not limited to, the ability of the parent to care for the child personally, the religion of the parent, the ability of the parent to attend to any special needs of the child, any immoral conduct by the parent that would have a direct effect on the child, the ability to give continuity to the child's current environment, and the availability of contact with members of the child's extended family. Child support is one of the most contentious issues in a divorce proceeding often, and there are guidelines for setting the amount of child support. The court considers many factors that influence the amount. Many states have guidelines that post the formulas for calculation, and these include the number of children, whether one of the parents provides health insurance, the net income of each parent, any special medical or educational needs of the child, and the standard of living the child would have enjoyed had the divorce not occurred. And there is a particularly helpful statute adopted in recent years which establishes child support guidelines. These guidelines have been adopted in most states to provide a formula that courts can employ to determine the appropriate amount of child support given the financial circumstances of the parties. And I'd like to end with a discussion of the other factors courts will consider when determining the division of marital property. The states follow two schools of thought with respect to property settlement in the case of divorce. Some states are separate property states and others are community property states. Separate property states take the position that all property individually owned before marriage is individual property and not jointly owned marital property. In addition, property acquired during the marriage through gift, inheritance, or personal earnings without contribution by the other spouse is also individual property. In a divorce action, parties are awarded their individual property respectively, and the court determines how marital property should be distributed. Community property states take the approach that the property acquired during the marriage through personal earnings is presumed to be marital property. Also included is property individually owned before marriage that the party contributed to the marriage, and when a spouse can establish that certain property was never commingled or otherwise shared with the other spouse's marital property, would be such property is not included in community property. This distinction is important because ordinarily the court will only divide the community property and not the separate property. And to divide the community property, the court will consider the contribution of each partner to the marriage and then attempts to make a fairly equal division of the property. Extraordinary circumstances must exist for the court to go against this. And with that, that concludes the Week 5 lecture, and I'll see you next week.